To Health and Care Conversations. Today's session is on claims following a data breach. You have myself and Catherine with you today. We are specialists in data law, and we are going to take you through the current landscape. If you wish to follow us on LinkedIn, please do scan the QR codes. They will also be available in the slides I'll send to you later. And instructions for how you do so are on the slide. So what we're covering today is what to think about when you're faced with a personal data breach, specifically from a litigation perspective. You've probably heard all about how to deal with them from a regulatory perspective and what you need to do in terms of notifications, but there are things to do to protect yourself. And you're protecting yourself from the types of claims the data subjects might make, so we will cover those off. We'll talk a bit about how the courts are approaching those claims, because that has been changing over the last few years. We'll talk about the range of compensation awards that have been made in these kinds of claims. And we'll also be talking about things you might think about when you're deciding whether or not to pursue the claim, whether or not to defend the claim, or whether to settle a claim. And then finally, we'll leave you with our top tips for what you need to think about when you're faced with one of these claims. So now I'm going to hand over to my colleague, Catherine, who's going to take you through the next few slides.
Good morning, everyone. So before we look at this topic in more detail, we always find it useful to cover off some of the key terms used in the data protection world, just to make sure that we're all on the same page. The first term on the slide is personal data, and personal data is anything that could identify a living individual. So it needs to be about a living individual, and that person needs to be identifiable. Personal data will include contact details, financial details, photographs, personal calendars, and anything about a person's family or lifestyle. Essentially, anything about an employee is likely to be their personal data. You don't need to see a person's name in a document for that person to be sufficiently identifiable from the content of the document itself. A person is identifiable if they can be properly distinguished from other individuals. So for example, if one of you were to describe me in an email after this training session as the associate from Mills and Reeves who delivered data protection training today, you haven't actually used my name, but I am identifiable, so it would constitute my personal data, even though you haven't used my name. The next key term is personal data breach. A personal data breach occurs when there is a breach of security which leads to an accidental or unlawful destruction, loss, alteration, unauthorized disclosure of, or access to personal data. The next two terms in the slide are two types of data which, if involved in a personal data breach, make the situation much worse in the eyes of the law, meaning both the courts and the UK Information Commissioner's Office. And those two terms are special category personal data, which is personal data which reveals racial or ethnic origin, political opinions, religious or philosophical beliefs, trade union membership, the processing of genetic data, biometric data, data concerning health, or data concerning a natural person's sex life or sexual orientation. The reason I'm highlighting this now is that it's the type of data to be treated with kid gloves. The other one is criminal offence data, and this is data relating to criminal convictions and offences or related security measures. The ICO also gets aggrieved if financial data is involved, which is considered to be sensitive but not special category data. Moving on down the list, the next term is data subjects. These are the individuals who enjoy rights under the UK GDPR, including the right to make a subject access request. So employees, visitors, patients, contractors, etc. are all data subjects. The UK GDPR also applies to all data controllers, and your organisations are a data controller in every scenario where they determine the purpose and the means of processing of data. In today's training, we're looking at the potential litigation consequences that may arise out of a personal data breach from the perspective of a data controller. In addition to key terminology, you also need to be aware of the GDPR data protection principles. There are 6 data protection principles under the GDPR, which are outlined on the slide. Those principles are that the data must be processed lawfully, fairly, and in a transparent manner. It must be collected for specific, explicit, and legitimate purposes. It must be adequate, relevant, and limited to necessary, accurate, and be kept up to date. It must be kept in a form which permits identification for no longer than is necessary, and it must be processed in a manner which ensures appropriate security. There is also an unofficial seventh principle, and that is of accountability, which in essence means you need, in all cases, to be able to demonstrate your compliance. Clearly, our attention today is on Principle 6, the requirement to process data in a manner that ensures appropriate security. The need to protect personal data from improper access and use is an integral part of the GDPR and a big focus of regulatory activity. To paraphrase the requirements of Principle 6, a controller or another entity, when they are processing personal data on behalf of a controller, must have in place security measures which ensures only authorized people can access, alter, disclose, or destroy personal data. Those people only act within the scope of the authority. And finally, if personal data is accidentally lost, altered, or destroyed, it can be recovered to prevent any damage or distress to the individuals concerned. So what if a data controller does not fulfill its Principle 6 obligations? A lack of security will not necessarily lead to a data breach. In a personal data breach, the data is lost, altered, destroyed, or accessed by someone who isn't supposed to have it. A controller may be lucky and somehow dodge the many opportunities for a data breach to arise. However, a lack of appropriate and adequate security vastly increases the risk of a breach. At the same time, you can have a data breach even where the data controller has excellent security measures in place. It happens often. Security measures in the form of both technical restrictions and organization rules and protocols may be put in place by a controller, but if they are ignored by staff or circumvented by third parties, it could still result in a personal data breach. Please be aware that a data breach can be an entirely internal affair if your staff are not taking their GDPR obligations seriously. Not checking attachments to an email is a common scenario. A prime example of data being lost to a third party despite the data controller fulfilling its Principle 6 obligations is the Morrison case. In that case, a disgruntled Morrison audit employee copied the Morrison's payroll and HR data and released it onto the dark web. The loss of the data to the employee in his personal capacity was unauthorized and constituted a data breach. The employee circumvented the many layers of security that Morrison's had in place and promptly caused what has become one of the most well-known data breaches to date and resulting in one of the most well-known legal cases resulting from a data breach. 1,500 employees tried to sue Morrison's as a result of that data breach. They ultimately failed, but Morrison's had to fight all the way through to the Supreme Court to achieve that verdict. During the proceedings, the court looked at whether Morrison's had breached Principle 6 and found it had not. It had implemented many security precautions and had a good process in place. But no matter what you try, you cannot fully defend against a perfectly placed malicious insider. So what kind of data breaches are most common? The ICO has handy tools on its website to provide a good overview of what is happening in the data breach space. Well, that's for data breaches that actually get reported, which is in itself a problem. The statistics indicate that perhaps notifications are starting to tail off. Apparently, across the EEA, the average number of data breach notifications per day fell from 328 to 300 in the past 12 months. The reduction does not make sense when contrasted with the uptick in cyber attacks on businesses. It is possible that organizations are becoming more wary of notifying breaches, although equally, it may just be that they are becoming more confident in their analysis of situations and are no longer making a notification just in case. In any event, the vast majority of data incidences are not caused by external malignant forces, but instead are caused by employees emailing the wrong recipient, employees posting or faxing to the wrong numbers and addresses, employees failing for phishing scams, employees losing papers or devices, and employees failing to properly redact things. At the time of, and even before a personal data breach has occurred, there are certain steps you can take to protect your organisation from a regulatory and litigation perspective. First, focus appropriate resources on the problem. Ideally, you will have a sound practice incident response procedure that guides you through the containment, recovery, assessment, notifications, and remediation action required. Your incident team needs to be predetermined. They need to know who they are and be familiar with the relevant procedures. You need to have worked out how decision-making is going to happen in what can be a very fast-paced and stressed situation. Top marks here if your team has had the opportunity to practice a response in a pretend environment. Mills and Reeve have recently undertaken a cyber attack survey and is about to publish its reports on cyber attacks. We asked respondents how much of the mandatory content on the personal data breach notification form they would be able to identify within the 72-hour time limit to report the incident to the Information Commissioner's Office. It is notable from the responses that there was doubt expressed for every single aspect. It can often take weeks or months to understand the full effect of a cyber attack, which is why it is so important to have the right people on the job as soon as possible, so that you stand as best a chance as possible in mitigating the effects of that attack. Second, the second step you can take is to anticipate the types of incidences you may suffer. Again, this could and should be considered before an incident occurs to give you the best possible chance of minimizing the fallout. If emails are prone to being missent, what steps could be taken in the immediate aftermath to mitigate and lessen that impact? If your website suffers a denial of service attack, would that impact on operations in any way, or would it be more of a reputational management issue? If you have a malicious third party who gains entry into your servers, how will you handle this? Which servers are most critical and could cause you with the most issues? By anticipating the types of incidences you may suffer, you can pre-prepare cheat sheets or flow diagrams to be relied upon in an emergency. Finally, always seek to protect your documents and communications. At the time a personal data breach occurs, a data controller's biggest concern are often operational and reputational, which is entirely understandable. However, communications and other documents created while investigating the incident may be disclosable to regulators and in the event of a threatened litigation to the other side. During an incident, there is disruption and people will be incautious in what they say and write down. Positions are often taken and admissions are made based on an often incomplete understanding of both the facts and the law. The words that get used will matter. For an example, an email headed data breach sent immediately upon a discovery of an incident, which is later assessed not to be a data breach, may be seized upon with glee by the other side in subsequent litigation. Staff should be using more neutral terms. Even simply data incident would be better. Apologies can also be problematic. Just because someone is unhappy with how their data is processed does not mean that the controller has done something wrong. In one case we had, a spreadsheet was circulated within a data controller to managers for them to complete with necessary additional information. Staff were listed by both name and address for identification purposes. One staff member was unhappy as she had recently left an abusive partner and she did not particularly want managers knowing her address. Regardless of her preferences, the use of her data was benign for a legitimate business purpose, and the data was only shared with managers, so presumably responsible people, who were all under obligations of confidentiality. There was no data breach, but early into the investigation, when the employee first complained, one of the managers apologizes to her and said it was a data breach and that it should never have occurred. From a perspective of a litigator, walking back an early apology and admission that should never have been made was really, really difficult. If the data controller staff had not jumped the gun before taking advice, the employee would probably never have tried to bring a claim in the first place. To avoid having to disclose and explain unhelpful documents to regulators or courts, where possible, consider surrounding your response to an incident with legal privilege. To protect that material, lawyers need to be the hub via which instructions are given. Copying lawyers in is not enough. If you can protect your documents with privilege, this may prevent unhelpful statements or admissions being provided to the regulators, courts, or aggrieved third parties. When looking at whether to notify anyone about a personal data breach, you essentially have 4 questions to answer. Number 1, are we legally obliged to notify the regulator? Number 2, if no, should we notify them anyway? Number 3, are we legally obliged to notify the data subjects? Number 4, if not, should we notify them anyway? Under the UK GDPR, if there is a personal data breach, a data controller must, without undue delay and at least within 72 hours after having become aware of the breach, notify relevant data protection authorities, unless the breach is unlikely to result in a risk to the rights and freedoms of natural persons. The holy grail for many data controllers in a data breach scenario is to have a breach that nonetheless does not need to be notified. The focus of risk regarding breach reporting is on the potential negative consequences for individuals. Article 85 of the UK GDPR explains that a personal data breach may, if not addressed in an appropriate and timely manner, result in physical, material, or non-material damage to natural persons, such as a loss of control over their personal data or limitation of their rights, discriminations, identity theft or fraud, financial loss, unauthorized reversal or pseudonymization, damage to reputation, loss of confidentiality of personal data protected by professional secrecy, or any other significant economical or social disadvantage to the natural person concerned. So when assessing risk, you cast your net wide and take a long, hard, objective look at the impact of the breach. The guidance and implications from the legislation was that data breach risk should be assessed prior to any mitigation that the data controller uses to try and reduce risk. England appears to be gradually diverging from this approach. If you follow through the report and breach assessment on the ICO's website, it indicates that if you can lower risk by applying mitigations, you can avoid notification. Your objective, therefore, should be to apply sufficient mitigations to bring the risk from high to pretty much non-existent. Even if you decide that there is no legal requirement to notify, you then need to go on and consider whether you want to do so anyway. Is there a chance you need to do so in order to obtain some sort of benefit? Are you very risk averse and would like to put in a protective notification? Once you've worked out whether to notify the regulator, you then need to work out whether to notify the data subjects themselves. Even if you need to tell the regulator, you may not need to tell the data subjects. The ICO actually discourages over-notification, as they do not want people to have notification fatigue, meaning that they have received so many notifications they just stop caring. Article 34(1) of the GDPR states, when the personal data breach is likely to result in a high risk to the rights and freedoms of natural persons, the controller shall communicate the personal data breach to the data subject without undue delay. This applies if the high risk persists after efforts to mitigate. It may be that you have a stubbornly high risk that you cannot get rid of. In such cases, you need to work out the best way to notify the affected data subjects. If you've managed to reduce the risk down, it is a much more difficult discussion. You may have groups within your organization who are pushing for disclosure of the breach to the data subjects. However, telling a data subject when you do not have to will open you up to higher reputational, regulatory, financial, and litigation risk. Something that an organization could potentially have simply learnt from and moved on may turn into a multi-year litigation event. Decisions on notification, especially if it's not legally required, should always be taken by senior decision makers. I'm now going to hand over to Claire so she can talk in more detail about the types of claims that data subjects can make.
Thank you, Katherine. So, as you know, a data subject whose data is involved in a breach may complain to the Information Commissioner's Office. For a data controller, that is unwelcome, but it has the benefit that it is free for the data subjects to do so. and the ICO has no power to award compensation to those data subjects. There is some risk that the ICO will commence an investigation into the data controller's handling of that data, but so far, that seems to be a fairly infrequent outcome. The lesser considered risk is that of litigation. So what can a data subject claim for? What is the litigation risk? That's what we'll look at now. First, we look at claims under the UK GDPR and the Data Protection Act 2018. Data subjects have a direct right of action against any data controller who contravenes the GDPR or the Data Protection Act in relation to their personal data. If the person suffered either material or non-material damage as the result of an infringement of the UK GDPR, they have the right to receive compensation from the controller or a relevant processor for the damage that has been suffered. There is a defence for controllers and processors who can prove that they are not in any way responsible for the event giving rise to the relevant damage, but it's actually quite hard to show that. Material damage includes financial loss and personal injury, such as mental health conditions which are caused or exacerbated by the breach. Because the right to compensation extends to non-material damage, this means that data subjects can also seek compensation for distress, which you will appreciate is a fairly amorphous and subjective concept. However, there must be something that counts as damage. For a while, it was thought that a mere loss of control over data or a technical breach might be enough to make a claim. At least the various solicitors who take on this kind of work from the claimant side were more than willing to assert it. But a case from 2019 known as Lloyd and Google essentially put an end to that. Where there has been a one-off trivial data breach with no credible case that any distress or damage over a de minimis threshold can be proven, a case actually has a good prospect of being summarily dismissed by the courts. And that was the position taken in a case called Rolf and Viel-Wasbra-Vizards, which is slightly difficult to say, where due to a one-letter difference, a school's lawyers sent an email attaching a statement of account to the wrong email address. Very little personal data was compromised, and the missent email was duly deleted by the incorrect recipient. The court struck out the claim, as damages were, quote, plainly exaggerated, and the breach was trivial. The suggestion, according to the court, that any distress or worry was caused was, quote, frankly, inherently implausible as a suggestion. There is also a possibility that claimants will try to claim for breach of confidence. Breach of confidence arises where information that is supposed to be kept secret is disclosed. A claim for breach of confidence may be brought against a person or an organisation that has used or disclosed or threatened to use or disclose confidential information without permission. There are three elements to a breach of confidence claim, which can be summarised as the information must have what's called a necessary quality of confidence, so it must not be widely known or common knowledge, and it must be substantively worthy of protection. Second, the information must have been imparted in circumstances imposing an obligation of confidence. This usually arises in specific relationships, such as doctor and patient communications or lawyer and client. But it can also arise if the person making the disclosure makes it clear that they do expect confidence to be kept. And finally, there must be actual unauthorised use of that information to the detriment of the person or entity who originally communicated it. If those two options aren't available, they might try misuse of private information. Private information can be different from confidential information. Private information is personal information which is private because of its very nature. Perhaps it concerns a person's health. In the original cases where this particular talk was developed, it was all about the disclosure of somebody's attendance at Narcotics Anonymous sessions, which clearly is not something that they had communicated to the people disclosing it, but they didn't want to be spied on and have that splashed across the national newspapers. So it's a type of information in which a claimant is said to have a realistic expectation of privacy. Claims are considered by looking at two specific points. First, did the individual have that reasonable expectation of privacy in relation to that information? And second, did their right to privacy outweigh the proposed defendant's right to freedom of expression and freedom to provide the information. Where private information has been misused, which is an active thing to do, damages can be recovered for the individual's loss of control over the private information and the distress, anxiety, injury to feelings and embarrassment they have suffered as a result of its disclosure. If those three options weren't enough, to make sure they've covered off all the usual possibilities, claimants also often look to the law of negligence. For a claim in negligence to succeed, as learned by law students across the land, you must establish that there was a duty of care owed by the defendant to the claimant, the duty was breached, the claimant's loss was caused by that breach of duty, and the loss was a foreseeable consequence of the breach of duty. So for a data breach, a claimant has to identify a common law duty that the data controller owes to them, demonstrate it was breached, and cause reasonably foreseeable loss. You'll see on the slide there is also a fifth option. It's a bonus for public authorities. Claimants like to add a claim that the authorities have breached their human rights, specifically their right to privacy and family life. Due to the kitchen sink approach of many claimant firms and the prevalence of copy and paste, claims for breach of human rights also often appear in litigation against private companies. In such cases, they can be dealt with quite shortly by pointing out it simply doesn't apply. So what's the overall takeaway from that? There are a variety of ways that a data subject can attempt to bring a claim. Each one of them requires specific criteria to be fulfilled for those claims to succeed. And just so that you're aware, in many cases, on an objective assessment of the facts, individual cases don't often fit the criteria very well at all. Litigants, and in particular those with legal representation, are supposed to carefully consider the possible claims and only put forward those with a chance of success. In reality, approaches tend to be a bit more scattergun, meaning that as a defendant, you have much more to deal with and have to delve much more into those facts. In a positive development, the courts are beginning to act in relation to this behaviour, and the pleading of multiple heads of claims has been subject to expression of disapproval by the courts. It's been made clear that the courts will filter out overlapping, opportunistic and insufficiently explained claims, which are likely to obstruct the just disposal of proceedings and use a disproportionate time and resources. The courts have limited time, they have limited resources, and they don't want to be dealing with some of this. So one example is Warren and Dixon Store Group. Mr. Warren brought a very low value claim against Dixon Store Group Retail following an incident in which cybercriminals compromised the personal data of Dixon's customers. He alleged breach of data protection principles, negligence, breach of confidence, and misuse of private information. The court took the position that a claim in breach of confidence and or misuse of private information couldn't actually succeed without some actual use or misuse of the information by the defendant. And the court said that a failure to secure data, which is in breach of Principle 6 of the GDPR, is not use of the data. As such, Mr. Warren could no longer pursue those extra claims. The court also rejected his claim in negligence because it said where a statutory duty exists, the common law doesn't need to impose another one. We don't need to pluck one out of thin air. We've got one, it's written in the statute. The court disapproved of the practice of simply throwing all options into the pot and hoping one or more would stick. In Eastside Community Homes in Johnson, the claimant, Ms. Johnson's rent statement, was accidentally forwarded by email to a third party, who subsequently deleted the email when requested. Fine. Ms. Johnson brought a claim in the High Court for damages capped at £3,000 for misuse of private information, breach of confidence and negligence, and under the GDPR. And in the specific case, she was concerned about her address, which was included in the statement, becoming known to her ex-partner. The court struck out every single claim except the one under the GDPR. So responding to these sorts of claims, whether you're doing it as pre-action correspondence or whether you're filing a defence, requires detailed knowledge of each type of claim. This will prevent you making unnecessary admissions or concessions, and it will also optimise the possibility of having the claim struck out. Now, looking now at the quantum of damages and how much might be awarded if a claim is brought, it's very difficult to predict the level of damages to which a claimant might be entitled, mainly because it is highly contextual. It depends on the facts of each case, including the severity of the breach and the individual impact the breach had on that claimant. Multiple claimants on the same facts can receive wildly differing amounts. Claimants might be entitled to damages for psychological injury, which will depend on factual evidence about those injuries and expert evidence. Damages will reflect the harm suffered by the individual. Therefore, quantum in cases, as I say, varies significantly depending on the facts. But as a benchmark, the guidance on psychological injury compensation is often referred to in order to quantify distress, although the figures are not always strictly applied. So the Judicial College guidelines provide some general guidance as to level of damages that could be awarded as a result of distress, and these amounts are illustrated in this table. The factors taken into account when valuing claims of this nature are the injured person's ability to cope with life, education, and work, the effect on the injured person's relationships with family, friends, and those with whom he or she comes into contact, the extent to which any treatment could be successful, future vulnerability, prognosis, and whether medical help has actually been sought. There are also levels of damage guidance for post-traumatic stress disorder and sexual or physical abuse, which can be found in the Judicial College guidelines. As well as general damages, aggravated and special damages might be awarded. Aggravated damages look at the conduct of the defendant to see if anything has been done to increase the hurt or distress. Please note, lots of claimants will say that you have done something wrong which increases their hurt or distress. This is not necessarily reality. Again, as Katherine has mentioned earlier, please don't start apologising for things before you've thought about it and had a good analysis of what's happening. Special damages cover the financial losses and expenses incurred as a result of the breach, provided that such losses flow from the breach and they were reasonably foreseeable. The founding principle of special damages is the claimant should be placed back in the financial position they would have been in but for the breach. They should be no better off and no worse off than if the breach had not occurred. So some one-off data protection claims have been successful. Quite a lot of them are actually under the old data protection regime, but they do give a helpful indication of the amount of damages. They're shown on the screen, but just to give you a bit more information about some of them. In Greenyer and Plymouth hospitals, which was in the county court, damages of over £18,000 were awarded to a claimant. The claimant's previous partner, a nurse, had unlawfully accessed his medical records in breach of the Data Protection Act 1998, which I will note is a criminal offence both now and was then. And then the partner used that information to attend the claimant's family's home and speak to them about him. The breach had exacerbated a pre-existing serious mental health condition, caused associated financial loss, and caused considerable distress. So the county court held that a breach which caused personal injury was recoverable as damage, but it didn't give any aggravating damages. In contrast, Halliday and Creation Consumer Finance, which dates from 2013, the claimant was wrongly recorded by the defendant as owing funds to them. This information was then shared with the credit reference agency. Clearly, this then did harm to the person's credit reference. The claimant sought to rely on the Data Protection Act to claim damages for the harm to his reputation and credit rating and the distress he suffered. This went to the Court of Appeal, who awarded compensation of only £750 for distress and described that distress as frustration. In a more serious one, we have TLT and the Secretary of State for the Home Department and Home Office. The Home Office wrongly published the personal details of around 1,600 applicants for asylum or leave to remain on the internet. The claimants claimed for misuse of private information and breach of the Data Protection Act causing distress. The judge found that the facts of this case were similar to those of psychiatric injury and psychological injury cases caused by an actionable wrong. And so that's what he used in terms of guidance for how much should be awarded, those amounts that we've looked at on the previous slide. Following consideration of what would be appropriate compensation, he awarded claimants between £2,500 and £12,500. Interestingly, claimants 1 and 2 were actually a husband and wife who believed their security had been compromised, and they had genuine and rational fears for their safety and the safety of relatives. As I understand it, they felt it necessary to move from where they were living to the other side of the country. So to describe the totality of their experience as mere distress would be a misstatement and quite an understatement. So they were awarded £12,500 each, in line with awards for moderate psychiatric and psychological damage. Claimant 3 was actually their daughter. She was judged to have been protected by her youth and by her parents because they shielded her knowledge of what was happening. She did have some genuine concern about her family, her schooling and friends. She had to move. And so she was awarded £2,500 for that. So as you see, there can be significant difference, and some of the mitigations that can be put in place, particularly for protecting minors, can reduce the amount of money that they get in compensation as well. In terms of another one that was pretty low, we have Driver and the Crown Prosecution Service, which actually just dates from 2022. The CPS provided an update on a possible prosecution that might occur against Mr. Driver to a member of the public in response to a Freedom of Information request. But there was no reason for providing the update to that individual, who then used it in a political campaign against Mr. Driver. So the court found that a breach had occurred. However, most of the information was already out in the public domain and could be inferred from what was already out in the public domain. So he was only given £250. So as I say, it all depends on context. It depends on what's gone out before. It depends on individual impact. And so it's very hard to assess what the likely damages are before you have the full facts available. Damages are also not your only consideration. Costs are an equally significant issue, and they should not be overlooked, because while damages awarded can be nominal in value, a claimant's legal costs can be quite significant. If a claimant is successful when they sue, the defendant is liable for the claimant's legal costs, unless the court considers it would be fair and just to depart from that position. If a claim proceeds to trial, those costs could be very significant, and we're talking in excess of £50,000 and potentially much higher. As such, there is sometimes real value in trying to settle the claim as early as possible before a claimant solicitor engages in tactics to incur significant costs. We have seen cases where these tactics have resulted in £18,000 or more of costs, even before the claimant solicitor starts putting pen to paper. Costs can very quickly become a barrier to settlement in claims. There's very little personal cost risk often to the claimant. That's usually an important pressure point if you want settlement, because claimant solicitors often operate on a no-win, no-fee basis or something similar. And also the claimant solicitor is very unlikely to agree a settlement which doesn't cover their costs. The courts have now made it clear that claims with values likely to be limited to a few hundred or even a few £1,000 belong to the small claims track, which has simplified procedures and limited, if any, costs recovery. So that's a bonus. The prevailing practice of claimant firms seeking to bring high court claims rather than county court claims and arguing for them to be allocated to complex tracks with higher cost limits is beginning to change. The courts are letting them know that that's not acceptable. But it will take some time for that particular ship to turn. Also, regardless of the court a claim has heard it, a data controller will be paying its own costs. And quite simply, you could be paying your own costs even if you win, because your claimant is quite unlikely to have the money to pay you. So responding to claims, whether in the form of pre-action correspondence or filing a defence, again, will need detailed knowledge of the type of claim. You don't want to make unnecessary admissions. You don't want to concede anything if you don't have to. And you need to optimise the possibility of having the claim struck out. Even a simple strikeout on the most basic of facts can cost you £10,000 or more. Another issue to consider is after the event insurance premiums. If the claimant has after the event insurance, the claimant solicitors will try to recover that from the defendant, the cost of the insurance premium, that is. So after the event insurance pays out in the event that a costs order is made against the claimant. They can be very, very expensive. The insurance premium can be as high as between 20% and 50% of the amount of costs being insured. So you could be looking at anywhere between £10,000 and £40,000, depending on what they thought it would take to bring this particular claim to trial. Now, after the event insurance is actually one of the reasons why most claims include multiple heads of claims, because after the event insurance only pays out if you can succeed in a claim such as breach of confidence or misuse of private information. A pure data protection legislation claim, it won't pay out, which is why you'll be faced with many, many options, despite the court's view on that particular issue. And the final point that you need to consider is reputation. A data breach can quickly cause immeasurable damage to an organisation's reputation. That could be damage to its brand, public perception, customer trust, the regulatory record of the company, its bottom line or its share price. In more recent years, the media has taken a greater interest in what organisations do with personal data, and a data breach that attracts media attention can have significant adverse consequences. The power of social media, coupled with individuals who are much more clued up on their data rights than they were before, means a relatively minor breach can spiral into a much bigger situation than originally anticipated. One way to stop it spiraling may be to settle quickly. And in all of this, don't forget the regulator. When you're handling claims, you need to keep in the back of your mind the fact that anything you say may be of interest to the Information Commissioner's Office or to an EU regulator if you have an international angle to your data breach. Someone within the data controller, someone in the team dealing with the data incident, needs to have a strategic overview when the breach occurs to try and prevent decisions and actions in one area from negatively impacting another. Data regulators have been given a very big stick with which to keep data protection, and fines for breaching the rules can be significant, up to £18 million. You should also be aware that directors, senior managers and senior officers within the client may also be liable under Section 198 of the Data Protection Act. If an offence is committed by an organisation under the Data Protection Act, and it's proved to have been committed with the consent, connivance of, or be attributable neglect on the part of a director, similar officer, or someone acting in that capacity, that individual can have liability. Under the GDPR, fines administered can be very significant, as I said, but they are all based on 10 criteria. And things that will be considered include the gravity and nature, so the overall picture, which is why you need to know the facts, whether or not your incident was caused by intentional behaviour or was the result of negligence. What mitigations have you put in place? What precautionary measures were in place? How had you prepared? Do you have a history of infringements and reports to the data protection authorities? Have you notified relevant people? And did you do anything to aggravate the issue? All those factors are equally relevant in litigation. I will also note the ICO now has more incentive to impose fines because it can now keep a proportion of every fine. Previously, all the money went into the Treasury pot. So here's our key points from a litigation perspective for you to take away. As I mentioned, if you have questions, please do put them in the question and answer. But to reiterate the key messages from today, just because someone's unhappy with how their data is processed does not mean that the controller has done something wrong. Don't give apologies and make admissions before you have taken appropriate advice. So avoid admissions. Protect your documents. always seek to protect documents and communications. Communications and other documents created while investigating a breach may be disclosable to regulators and, in the event of a threatened litigation, to the other side in that litigation. Consider very carefully whether you actually want to notify a data subject. Telling a data subject about a breach when you don't have to will open you up to higher reputational, regulatory, financial, and litigation risk. So consider it very carefully before acting. And quantum of damages and fault are two factors, but not the only factors to take into consideration when facing a data breach claim. Litigation can be really expensive and it's unpredictable. You need to develop a plan of action at the outset and pursue it quickly in order to keep costs down and get the best results. So right at the start of the claim, you need to be considering whether to apply to have it struck out or whether you want to settle. So thank you very much for attending today.